We said, but
So, yeah, we gotta look for,
How are you?
Paris. Thursdays are my long days. I have class starting at 9:30 and then I don't get any breaks until, yeah. But my meeting I normally have at 3 today is canceled this week, so.
So when you're done here today, you can kind of take a breath.
Yeah, I can breathe for a little bit, yeah. It's really weird because Wednesdays are a big work day for me because I only have like one meeting, so I can just like work for 6 hours in a basement room. And then like I leave it, I'm like, man, here's my next step I need to take, and then I can't do any work for like 48 hours. Cause I'm like running through classes and stuff, so I'm not, I like have this note of like things I need to do and I'm in the mood, and then I have to wait 48 hours to do it. Yeah, how are you doing?
Good. Usually I get a break between like an hour, not even an hour, probably like 30 minutes between, but I had to do like stuff for the front desk because we did a few checks with police. Make sure there's like operating properly.
Fair enough, yeah.
Which is good.
Mhm.
So I'm glad we did that. How are you?
Good, how are you?
You're back.
Yes, when did you get back?
I got back Sunday. At like 8. I got in my house.
Let's get the owl down a little bit, because we're kind of shifted from each other, just so.
That's okay. I hope somebody in the future comes on and looks back at the past part of questions that I want.
There's like 10 minutes of preamble in like all of them, so like.
should put
The
that-
historians will have a good time.
You can do that retroactive.
Brandon said he'd be late, Jacob's not gonna be here, so I think this is us for our team.
Mhm.
Yeah, I'm just waiting to see, Olivia.
Okay.
She should be hopping in any second. So as soon as she hops in, we'll start.
I'd be surprised if she just finished her thesis then.
She
I
said
mean, I wouldn't be here.
she said she was planning on it just to like be here. I don't think she was gonna like be very. Like I said, I think it was kind of, but if she just defended this morning, I think.
I
it's-
wouldn't
Yeah,
be.
she's not-
Yeah.
Yeah, I think she was very ambitious. She was gonna, I was like, I don't think you're gonna want to, but you know.
Yeah, I can't remember wanting to do anything of any responsibility immediately when I left that room, and I got a couple handshakes, got a high five, and I was like, all right, I need to go do something to decompress. I'm not doing anything of any professional responsibility for the rest, I think I took the rest of the week off, like frankly.
I mean, yeah, you deserve it at that point, right? Like you've been working for years to this point.
Well, cause I was, when I did mine, I was still working full time. Like I wasn't like, so I was already, at that point, I was working full time as a school administrator, so I was like, when I was like, I took a couple days of vacation when I was done.
Olivia has joined now, by the way.
Oh,
I
perfect,
just joined them.
awesome. Let me get the email over to you. I think we'll have maybe 8, if we
Okay.
get through them all.
Okay. I didn't make a note.
2, 3, 4, 5, 6, 7.
Okay.
7.
You mind sending that over?
I'm doing right now, yeah. Yeah, Curvenz, right?
Yeah.
Uh, Now, I will tell you, one of these, we've had a bad version issue with. So, and it's number 9, like I've had to undo and like reopen the previous, like I've had to do the version history thing a couple times in the OneDrive, so. If there's any questions about it, like the one that I'm gonna physically give you is definitely the right one. I've checked it and it looks correct, but I just wanna bring that up.
Sure.
So we've got 9. Twenty. 1.
Yeah.
2.
Okay. I just remembered.
Thanks for reminding me.
3. Four.
Oh, I don't know if you saw my post about the survey.
I did.
Okay.
Well, that was just today, right?
Yeah,
Haven't done anything about it.
yeah, that's fine. I just wanted to put that on there.
Is it on the comms thing?
I put it on the to-do list as well,
It was. Got it.
but it was in bug.
That is hard.
Okay, you guys ready? Oh, wait, did you just leave? She's supposed to rush. Okay, just wait, just another minute or two.
Well, in the meantime, I wanted to ask something. So, in previous years, when people wanted to take like an OPS position in addition to their GA position, they
Mhm.
had to fill out some kind of form or something like that.
She's
Does
my
my-
perfect person.
Okay.
By the way.
Okay.
Cause I don't have the technical history on that,
Okay.
like, let's ask Dr. Travis, cause I think she'd be able to talk to it better. I'm not like refusing to answer, but she's gonna be the
No,
one to
sure,
know.
sure. I mean, we've been getting questions about, previously, people had to fill out a form, if they wanted to be OPS workers in addition to their GA position. and
Okay.
Yeah.
It's regarding the principles of employment.
Mhm.
It's actually to protect graduate students. So it's based on the job duty. So when a unit wants to go hire a GA, OPS, it'll go through HR, and if they recognize the duties to be GA related,
Mhm.
they should appoint as a GA. Unless it's very temporary. So in the College of Engineering, you have NSF students that are on a stipend from NSF that want, well, let's just get that right there, they're GA.
Mhm.
And they want to go do an internship. They will do a research leave of absence internship for that, but the dates don't align with our appointment calendar.
Mhm.
So they'll hire them temporarily for a week or two at the beginning of
Okay.
like, let's say, classes end of spring to May 10th. Then they leave, then they come back August 9th,
Mhm.
but the appointments don't start till the 16th.
Right.
So they hire temporarily. So if it's very episodic, so really, it's not like, no, graduate students can't, it's not that at all. It's what are the duties that they're asking the graduate student to do? Because we don't want a unit getting out of,
Making people
proper-
OPS workers, yeah, sure.
not do a tuition waiver, not give you health insurance.
Right.
That's why the graduate school wants to look at it. And that's how HR looks at it. They don't look at it as a restriction, 'cause, you know,
Right,
I hire student assistants that have a GA.
right.
It's that, it's the work,
So-
we're really looking at the work.
So.
Is a unit wanting to do that, they could just reach out to me.
Yeah, I actually don't quite remember what the context for this was, but yeah.
The person in question, I believe, was already a GA
They can have
and
an
they
OPS.
wanted to also do OPS.
Yeah.
But they,
But they
they still need to fill out the form.
Yeah, and then if it's gonna exceed over, like, let's say 0.74 FTE, we also wanna look, because we wanna make sure the student hasn't reached, will be reaching their milestones. And typically, when they're doing above a 0.74, those students are like ABD. That's typically what I see, like, informally. So, yeah, and the unit can or that student can reach out to me, and I can explain that as well. Yeah, for sure.
Great. That kind of, yeah, that was all.
Okay, Olivia, can you hear us? I shall make sure the audio is.
Yeah, I can hear you fine.
Okay, you guys ready to get started?
Yep.
Okay, so why don't we start with, Article 9? We'll just go in order.
And you share your screen.
Yeah.
So, on Article 9, we made quite a few changes, but honestly, I think a lot of the changes that you're gonna see are related to your request to include some of the language that, that you all had suggested, which I think you're gonna see that we actually accepted it, we just contextualized it in adding quite a bit more than you all had requested, so let's go ahead and start sort of in 9.1. Is defined as the freedom to discuss. I don't think that necessarily has a terribly substantive impact there. So here we have the university and UFFJU shall maintain, encourage, protect, and promote employees' academic freedom consistent with this agreement, all relevant regulations and state and federal statutes. So we just want to make sure that, first of all, it's not just us, but it's also you all as well. And then, you know, at times, we don't want to necessarily get into whether or not, you know, the interpretation of 9.1 is or is not legally properly constrained by regulations, state and federal statutes. So that's what we've added in that section. The, in 9.2, well, Brendan. I think I gave you enough copies that you can have one too.
Yeah.
So in 9.2, you're gonna see, that what you have there in A, we've actually, I believe we've kept it, but we've just moved it down to 9.5, and I'll sort of explain why we did that when we get to that section. So for all intents and purposes, 9.2 is not changed, but the changes that are there, notwithstanding the sort of the internal severability clause, which that part, we did not take.
Wait, what do you mean by the internal?
So I kind of view that as, again, we're talking about the passage of university regulation and policies and so on and so forth. I think those clauses, in a general sense, we would like to, and you'll see this, I think, when you see our 25 and 28, because we've had conversations on most of these articles about, we want to make sure that it conforms and is consistent with 25 and 28. I think what we would rather do is let's make sure that 25 and 28 are good, so that we don't have to include a reference to them in all these
In
other
every
articles.
Okay.
So anyway, so we didn't take that one. In 9.3, oh, and C, you have GAs are entitled to freely express their political beliefs and or affiliations. However, they should be careful not to persistently introduce matter unrelated to their subject of their teaching. That test that you have described is not a test that we're interested in trying to figure out and investigate and get into disagreements about. So what we would rather do is give
The test being persistently
introduced matter. So then there's a test of persistence, there's a test of relationship, whether or not it's relevant. We just feel that's gonna be sort of a problematic sort of a thing. So rather, we would give a more comprehensive explanation of what we believe it is, which we've done below, and then we can talk about whether or not you believe that's appropriate. So in 9.3, every GA is permitted to freely discuss subjects within their domains of expertise, as well as to explore ideas, pursue inquiry, and maintain their opinion and conclusions relevant to those domains. We believe that what we believe your intention is in C is captured there. And obviously we can discuss it if you don't think it is. 9.4, academic responsibility of the
So
GA.
you're saying that this sentence in 9.3 captures the same sentiment as in 9.2?
We believe it does, because basically what you've done is you have said you're allowed to do this, and then you've provided a limitation.
Mhm.
And rather than doing a provision and then a constraint, what we've rather said is, let's just make it in a complete positive. And then if it is, like for your example, if it's a political belief that's related to the teaching, then it should be protected under 9.3, which says it's a subject within your domain of expertise and exploring ideas and inquiry, maintaining your opinions and conclusions that are relevant.
Well, so, I mean, 9.2 deals with teaching duties and 9.3 deals with research duties. So that's why we had it.
I gotcha.
Yeah.
Okay, let me go ahead and make a note about that. Bless you. All right,
Maybe that just
I'll
needs to be
make-
separated
I'll
into a
make a note
separate
on that.
clause.
Yeah.
Say every GA, but it's not limited to the research section.
Sure, yeah.
That's a good, I didn't look at it that way. All right. So down to 9.4. So here's what we had looked at with respect to, what you all had added in 9.2, which we believe was largely taken from the UFF contract.
That's right.
So in what you had taken from the UFF contract was actually not ascribed as a right of the faculty, but it was actually ascribed as a responsibility of the university. So what we felt would be more appropriate, because you all technically don't have the legal ability to prohibit something, like that's listed as ascribed. If you look at their contract, that's a university responsibility to prohibit that.
Mhm.
And you all can obviously check that out on your own, but, so we said, look, let's go ahead and bring over the pieces of those two clauses to try to look at that sentiment. So what are the academic responsibilities of the GA? And then what are the academic responsibilities of the university, so that it attempts to capture what pieces that we believe are relevant and meaningful, that we have a shared interest in defining. So looking at 9.4, academic responsibility of the GA, academic responsibility implies, and you'll see the lead in for 9.4 and 9.5 are very similar. One is ascribing the responsibilities to, your members, and then the other one would be to us. Academic responsibility implies the competent performance of duties and obligations and the commitment to support the responsible exercise of academic freedom by others. And then specifically, GAs have a responsibility to observe and uphold the ethical standards of their disciplines in the pursuit and communication of scientific and scholarly knowledge, treat students, staff, and colleagues fairly and civilly in discharging one's duties as teacher, researcher, and intellectual mentor, perform appropriate duties assigned by the university, and observe applicable state and federal law and applicable published college, university, and board of governors regulations, policies, and procedures, provided that the assigned duty or the regulation, policy, or procedure at issue does not contravene the provisions of the agreement or the GA's right to criticize or seek revisions of those duties, laws, regulations, policies, or procedures. GAs seeking a change must not do so in ways that reasonably obstruct the functions of the university. So I invite you to go ahead and take a look at that in the context of where you all had found the original language. And I think what you're going to do is you're going to find that it's very similar to where you had taken that initial place from. So then let's talk about on the other side, where we hung your language inside the academic responsibilities of the university. Academic responsibility implies the competent performance of duties and obligations and a commitment to foster within the university a climate favorable to the responsible exercise of academic freedom. Again, you'll see that it's very, very similar to the sort of lead-in provision for 9.4. And then here is where we've made some changes to it. So let's take a look. But I think we've captured the majority of the language. In a situation in which a GA is primarily responsible for a course or course section, prohibit disruptive student behavior. So here it is. The situation is the way we're describing it. The GA is primarily responsible, but the responsible party for doing the prohibition is actually the university, if that makes sense.
Okay.
Which again, please check it out for yourself, but that's the same construction we use with the other bargaining group. So prohibit disruptive student behavior, including behavior that involves violence against GAs, staff, or students, threats of violence, instigation of violence, malicious vandalism, possession of weapons of any type, willful disregard of a GA's legitimate directions, continued use of abusive language or gestures, or other behavior that is so unruly, disruptive, harassing, or abusive that it seriously interferes with the GA's ability to effectively communicate with other students in the class or with the ability of the students to learn. Now, here is the part that probably acknowledges what we believe your intention was, which is the university shall support the authority of the GA to direct a student verbally or in writing to cease engaging in the disruptive behavior. So this is where the relationship exists between who would have the contractual legal ability to actually prohibit, and you being, a teaching assistant being in the room there. We need to support that person if they're saying, hey, look, you need to cut that out, or sending an email saying, look, you did this today in class, it really wasn't appropriate, don't do that anymore. And then we would support, we have an obligation to support that. And then furthermore, the GA may report the conduct to the Dean of Students Office. In the case of an emergency, the GA should contact the University Police Department. And then going a little bit farther, upon receiving a report of disruptive student behavior, the Dean of Students Office shall act promptly to review and resolve the matter in accordance with the university regulations and policies regarding student conduct. And then B, a GA shall not be disciplined for taking reasonable action in self-defense or in the defense of others. So again, you guys have basically suggested kind of one paragraph, and I realized we came back with a whole bunch of language. But what we felt was, when we looked at it, first of all, I think we agree that we need to capture that sentiment about the fact that, look, our employees, your members, the GAs are oftentimes in situations where they're responsible for a course section and they are acting as the instructor in that room. Okay, so what are all the things that sort of attend that? Because the classroom management responsibilities, and interact, and sometimes things don't go well. Sometimes you have a negative interaction with another student, so how is that going to resolve? And what are the, what responsibilities does the GA have? What options do they have? And then what is the responsibility of the university to, protect and support the GA in the execution of that responsibility?
Yeah, so I think we'll have to go back and look at the UFS
Sure.
contract, but, so why is it that this is solely the, this is only something that the university can do and not the instructor, or
So-
why is it that the instructor delegated this?
Yeah, so you have to remember too, that you have a confluence in this case of, students also have due process rights. So, we're not going to delegate the authority to determine that a student should be prohibited from attending a class.
Right,
We're not gonna delegate that to you all, just like we don't delegate it to faculty.
right, okay. So I think maybe you possibly interpreted prohibit as in like prohibit them from like coming to class or something like that. Whereas I think it was just previously just saying prohibiting disruptive student behavior.
I get that,
Yeah,
I get that. Yeah, I think, here's the thing, if you all are making a determination that something is disruptive or inappropriate, again, our responsibility is to ensure
that
and
is
support you
correct.
in the management of that classroom.
Mhm.
But when it comes to decision about like student conduct,
Whether
not-
or not that was
like,
disruptive.
yeah, we're not gonna delegate that particular component over to y'all. And the other thing is, similar to where we have a reticence to include a lot of the details about our academic relationship to you, like we want to be very careful about that. Similarly, we don't want to put policies and procedures having to do with student due process and student conduct in your employment contract, because that really needs to be a matter of the dean of students office and the policies and procedures and, sort of the legal responsibilities we have over there.
If you don't mind, I'd like to ask a question.
Yeah,
I
go
feel
for it.
like 9.4.3 is pretty vague and I would love some clarity on the intent there. Zoom out.
Sure, perform appropriate duties assigned. Do you want to talk about a specific phrase or just want to kind of go through the whole
The whole
thing?
intent, because
Okay.
I'm trying to clarify, I think the last sentence is just striking me the wrong way, so I would like to contextualize it within.
Yeah,
the-
GA seeking change must not do so in ways that unreasonably obstruct the functions of the university.
So does that mean if somebody was teaching a subject matter that the university doesn't like, that would be obstructing the functions? Or I'm like wondering if that could be misconstrued or like what the actual intent.
Yeah,
of
what
this
does
entire
that
section
mean?
would be.
Yeah, so I think the concept here, and I want to defer to Olivia if there's any specific legal tests or termination or terms that we need to make sure that we use here, but I think the basic concept is the fact that, if you're looking to change something about the appropriate duties assigned by the university, or in general about the competent performance and obligations and commitment to support the responsible exercise of academic freedom, because it's within, that's the sort of the lead-in heading of 9.4. If you're seeking to change that or alter that relationship, you are not using your situation or position in a disruptive way. You're not standing in front of as a simple example, you're not standing in front of the classroom using that as sort of a bully pulpit to try to enact that change or to make, statements about that.
Mhm.
So you're saying only interrupting in the sense of the classroom or like their duties?
No, that was one example. Like I said, in other words, if you're looking to change the academic responsibilities between us and you, you're not seeking to do that in such a way that it is disruptive.
Well, okay,
So in your interpretation, if there was a TA who has access to like an email list of their students,
Mhm.
and they were to email their students about some sort of action in attempts to change policy, that would not be allowed.
I think it would it would probably depend on the fact specifics of that case, because that's pretty broad in general.
Mhm.
I will tell you from an educational perspective, in general, not necessarily about a TA, but I think that educators in general need to be somewhat careful about opining in front of their students about their own personal relationship with their employer. I think it can be fraught with difficulty and legal responsibility. Not always, but it can be. I think it's just something that you have to be careful about.
Yeah, I'll just say that, I mean, that example, that's really factually dependent upon what's being said and what capacity it's being said, who it's being said to. There's a whole First Amendment analysis that goes into that. I think that last sentence is just capturing the sentiment of Regulation 1.008, which governs disruptive behavior, which just says, disruptive behavior is behavior which when somebody intentionally acts to impair, interfere with, or obstruct the operations of the university.
yeah, I think a definition like that, Adam, might be good, because I think as it stands right now, let's say, for example, like if you're like doing like a protest or something, that could be seen as unreasonably obstructing the function of the university, depending on where you're protesting or something like that. I feel like it's a little too broad it could be used to prosecute stuff that should be protected, like actions that should be protected there.
We can consider that. I mean,
Yeah.
I think, again, we talk about reference in the very first
Right.
provision, but if you want it more localized, that we can consider some sort of regulation reference.
Yeah, because the lead in 9.4 it's, the whole section is pretty general, so
Mhm.
that's why I'm saying like it could be, it's not like limited to just a classroom or just like if you're in the lab, for example, so I think it's at least having a definition of, in this case, a definition of unreasonable, I think is warranted because of that, because otherwise, anything, you could do something very, yeah, I think like an email, for example, like you said, that's a very, it depends on the facts of the case, but usually an email out is not disruptive, emails are disruptive in itself, so.
Right. I think, back in Cassie's example, I think there's a difference between if you send one email to one person where you're discussing a subject versus
Of course.
I'm using my email class list for all my students, and you
Right.
send out some sort of opinion piece. Like,
Right.
those are,
That's-
again, that's why the facts of the
Yeah,
case sort of matter.
Yeah, okay.
So I realize there's a lot there and some of
Yeah.
it's pretty technical language. So, I mean, I appreciate that you guys want to take a look at it.
Yeah, that's really like the main thing. It's like when I see just kind of say unreasonably obstructive function of the university and that's it, it's just.
Yeah.
Yeah.
And like I said, I think what you should find is that the heart of what you all had proposed is in 9.5.1. That's where you're gonna find, I think, sort of the heart of what
Right.
you all had suggested and proposed in 9.2.
I have a question about 9.5.1 here. So, hypothetical, I don't want to get caught in the hypothetical
Yeah.
trap, but if you're 2 minutes into a 50-minute class, right, and you have students being very disruptive, and you say you support the authority to direct verbally or in writing to cease engaging,
Mhm.
and they don't listen to you, how do you get back on track as a TA if they're still being disruptive? Because you haven't had the power here to say, get out of class or something like that. That's a university thing. So how do you get back to teaching in that class?
So I think, and actually, it's right before we were here, Olivia and I were having a conversation about this. I think there's a big difference between you verbally encouraging a student to remove themselves versus you prohibiting them from having access to the classroom.
Okay.
And we talked a lot about, what are all of the particular, and it's a pretty broad range of skills and everybody does a little bit differently that go into classroom management. Classroom management is definitely more art than science and different, you've all had different professors and different teachers. People have very different ways of controlling classroom behavior. Some are much more authoritarian and that works because they have the respect of the students perhaps, or they're viewed as, they just have a reputation that precedes them. And some are much more maybe friendly and affable and maybe they do with humor. I mean, there's a very, very broad range of ways that you can control the classroom. I think that what we want to make sure we communicate to you is we have an obligation to support you in managing that classroom, and it doesn't preclude the education that you're attempting to facilitate and deliver to other students who are there to learn. And I think that in a general sense, we want to make sure that you understand, we recognize our obligation to help you and support you so that you can manage the classroom in a meaningful, responsible way, because that's what you're there to do.
Mhm.
And if you have students that are creating disruptions and they're prohibiting you from doing your job and others from engaging in learning, that is the mission supporting the university, there has to be ways that we can support you to make sure that gets back on track. I mean, that's what we're trying to accomplish. We clearly have a shared mutual interest in making sure that happens.
Yeah, I was just trying to make sure we weren't stuck in a bubble where we had the authority to, tell them to stop, but that's as far as we were allowed to go. And
Yeah, so
totally great.
could you repeat that part again? So you don't consider asking someone to remove themselves from the class to be prohibiting them from being in a class?
Yeah,
Okay.
again, Olivia, I want to be careful because you and I had a lot of conversation
Yeah,
about this.
no, I mean, I
Yeah.
don't think that I think part of classroom management can be that for a particular class session, if there is a student who is being disruptive and preventing you from providing instruction to the rest of the class, that you would have the authority to ask that student to leave the class. What you wouldn't have the authority to do would be to tell them to never come back to class again, because
Right.
that's kind of the distinction there. It's like you have, an emergent situation in front of you that you need to address. It's just kind of the longer term, we've seen circumstances where, where that has had to happen and it's, it's supported by the behavior. However, if in terms of long-term solutions, there's a whole code of conduct with due process that needs to be adhered to in terms of interim restrictions being put in place, saying a student can no longer have contact with you or attend your class and that sort of thing, and that goes to the dean of students office.
Right, no,
Right.
that's totally understandable.
Yeah.
I think, I mean, so I'll just say like an overall comment, like, I mean, I think I agree with your characterization. You
Good,
have
yeah.
tried to incorporate a lot of our concerns. And I think we will stick to the way you've organized it probably for our
Okay.
counter. There are a few things we probably need to add, including, I think, this distinction. I mean, because you guys are interpreting prohibit to mean like prohibit, like just don't ever come back to class.
Right,
And the way we intended it was more like what Austin was saying, like, you know, in a specific
Yeah.
moment, like you're saying, hey, this person is like,
We
I
have
cannot finish this class if this person remains
take
here.
control of the
Yeah.
class at that
The
moment.
short term versus
Yeah.
that long.
Yeah,
term,
right, right.
You know,
understand.
before the long process of the discipline goes into effect, like you need immediate action.
right. I think, one of the things that, you know, we had a lot of conversation about is regarding, again, everything that sort of goes into classroom management
Mhm.
and, you know, part of it, it's, you know, it tends to be a shared responsibility for establishing a wholesome, facilitating educational environment. And quite frankly, you know, there's a range of capacity that different instructors have for the ability to manage bad behavior. And it's why you have, you know, some students that may be perfectly fine, even if they are somewhat disruptive, but they're able to sort of, the instructor has either the strategy or the personality or whatever to make sure that it doesn't get to the point where it's actually obstructing other person's learning.
Mhm.
Whereas you go into another classroom with the same exact student exhibiting the same exact behavior, and that instructor has a different skill set or runs their classroom different and doesn't necessarily have that capacity. So I think that one of the things that we just want to be careful about is if it's like an explicit says, like, anytime a GA says you need to get out of the classroom, that's where it goes, because it's not quite that simple.
Yeah.
No,
There has to be an analysis of whether or not, like, there's a reasonability test
Mhm.
that would have to be applied in some way, shape, or form. It's not just like, you know what I'm saying? So I just want to
Yeah,
be sure
no,
that you
that's
hear us say that.
Yeah, and I'm trying to connect it to my wife is a high school teacher, so
Yeah.
you know, they have a lot of different classroom management styles, but they have the power at the end of the day to say, go to the office, you
Uh-huh.
know? Do we want to make sure that GAs have that right if they need it? We don't want them to need
Yeah,
it, but like if they need to say, you know, go out and then we'll do this process
Oh, okay,
that you have listed in here, then they have that ability.
well,
you know?
they have access to the Teacher Protection Act, the Reasonable
Yeah.
Force Standard. Like, there's all these other statutory implications that come into play that don't necessarily apply here. But I understand the general sentiment
Yeah.
of, look, you all have, if you're serving as a teacher of record in a room and you're responsible for facilitating the learning and the management of that classroom, you're not on an island completely by yourself doing your own thing. Like, you have, the university has set you up to do that. We have to help support and facilitate that effort. And if you're running into a problem because a student is being disruptive, we have an obligation to help support you in ameliorating that problem.
Okay.
I have one last question. with
Sure.
Legal, because I remember, I'm not sure if I heard correctly, but because in the original 9.2, recording class without permission,
Mm-hmm.
wasn't it said that like that students have a right to record classes and like, or something like that happened at some point?
I'm gonna have to, I don't honestly, I don't know.
Yeah. I remember-
Yeah, there was a law passed recently that said that under certain circumstances, students were permitted to record classes without permission. So I don't think we can include like a blanket prohibition on that. Would have to potentially be like unauthorized recording or something along those lines, because it was
Yeah,
a couple
that
years ago
language-
that law was passed.
Right, and that language was specifically put in there to address that.
Right.
Yeah.
Okay, just curious, 'cause I remember hearing about that. I just wasn't sure if it was for Florida. I didn't remember.
Yeah.
All right. All right.
Yeah.
All right. Okay, sweet, that's 9. All right, let's move on to 20. So I think we're really close on 20. Here's where we are. I think that the two sticking points are really both in 20.3. We are okay with, we've gone back and forth on basically 3 things: whether or not the investigation is obligatory, whether or not the word reasonable is included, and then whether or not the phrase good faith is added. And I think this is kind of where we are. We are okay with removing the word reasonable. We are even okay with basically what amounts to largely CCL, which is that the administrator shall investigate the conditions. And then, however, if the administrator deems a formal investigation is not warranted, they may request UFFGAU to waive the right to trigger an investigation. And that's actually, I believe that sentence was actually your suggestion, which we're okay with. The extent of an investigation shall be reflective of the seriousness of the safety violation. We're okay with that. And then we're okay with removing what we had suggested, which I think largely, what we had put was the rest of that, even though it's blue, I think most of what we deleted was actually our counter proposal. But with that, we do want, we're okay with removing reasonable, and we're okay with making the investigation obligatory, at least based on the language, but if we're gonna do that, then we really want it to be that there is a good faith standard for the report.
Okay.
And we think we don't necessarily need reasonable and good faith, and that the investigation is, like, we don't have to have all three things work. It has to be reasonable, and it has to be good faith, and we have a right to deny it.
Right.
But if we're gonna say, okay, we'll remove the test of reasonability, at least as stated, and we'll take on the obligation to investigate it, we want some insulation that if somebody's out there just making just
Right.
nuisance complaints, that we're like, look, you have to stop that.
Right. And what would the process in your mind be of starting, like, say you get a report and you think, and you determine it might be in bad faith, like, what would be the process to handle that? Cause I'm not, to like, say there is really a bad faith report, like, where, like, I'm not, I don't. really
So,
see,
I mean,
like,
it's a pretty high standard,
Yeah.
because what we would have to really determine is that was, I mean, and again, I'm not gonna use the same language that Olivia might, so I'll encourage her to cut me off, but the bottom line is there must be some proof that it was done with some sort of malice. In other words, it was intentionally
Right.
done to create a problem, or to
Okay.
waste time, or to be unreasonable, or that they explicitly knew it was untrue, or, they somehow manipulated evidence that they submitted, or, for example, this is just, like, let's say that you were to Photoshop a picture of a violation that you believed happened, like, you thought there was a safety violation and it was Photoshopped, and we know that the person Photoshopped it and then submitted it. Look at this problem.
Yeah.
Like, that's clearly not good. You photoshopped the picture, like, so I think it's a relatively high standard, because we
Yeah.
would have to say that there was some intent for it to be in some way, shape, or form
Okay.
disruptive, or intentionally skewing the information. Olivia, how did I do in explaining that standard?
Well, I think there's another kind of side of the coin where this comes in as well, which is that it happens with some, regularity, that you sometimes see an employee who has performance issues, and then, the writing is kind of on the wall that they might be subject to some type of, non-renewal, or like and I'm speaking broadly here, not about GAs, but, and then they start filing complaints, and then they think that because they filed a complaint that they're then protecting their employment. And this is something that is contemplated by pretty much every anti-retaliation law, which is that, if you're going to bring a retaliation claim, it has to be based on a good faith report. So that's kind of where this language is coming from. So it's like, this is just a way of capturing kind of that anti-retaliation language that you see in almost every anti-retaliation law out there, which is that, you're only protected from engaging in a protected act, you're only, you can't be fired for engaging in a protected activity as long as were engaging in that activity in good faith. So you can't essentially create a shield. You can't shield yourself by making a bad faith report, if that makes sense.
Right. I mean, I feel a little bit better hearing that explanation, because good faith, I mean, if it is that high of a standard, that makes me feel a little bit better about including that in.
Yeah,
Cause it seemed like before, it's just like, if it's good faith, then yeah, I don't know, I just feel like anything could be bad faith, but if it really has to if you have to prove the intent pretty much, and that is a pretty high standard, and that's a little bit more considerable than just.
Well, and it also doesn't absolve the university of meeting all the standards we would normally have to meet for taking some sort of adverse employment action. I mean,
Right.
it's not like a get out of jail free, oh, we think
Right.
you did this, bam, here's some
Yeah.
discipline. Like, we still have to meet all
Of
the other
course.
tests that we would have to meet
Okay.
for
Yeah.
disciplining,
Okay. Yeah, and I don't think, and again, this is probably gonna be very rare anyway, if ever, it's a
Yeah.
bad faith report.
Yeah, it is pretty, it is pretty unusual that people make a habit out of, like, making either continuous or nuisance complaints. I mean, oftentimes,
It's trouble for them as well.
exactly, because then they're gonna have to answer questions, and
Yeah.
sometimes people are out for the attention, but that's pretty rare. I
Yeah.
mean, like, to Olivia's point, I mean, I've seen it quite a few times, not in this role, but in my previous role, where, okay, so now the person's either up for some sort of major discipline, or maybe they're in the process of being let go or separated, and
Right.
now all of a sudden, they're contacting and levying complaints in every office they can
Like
get a hold
OSHA or
of,
something,
whatever,
yeah.
yeah, exactly.
Okay.
So,
Alright.
I think the other changes are ones that we've already sort of looked at and agreed to, and with regard to removing 20.7 and the 20.8 should be, just the takeover from the previous reopener.
Did you ask about the OPS?
We did,
Yeah, we did. Okay.
So we good on that one?
Mhm.
Yeah.
Okay, all right, let's move on to 21. Check. So I think what you're gonna see, and it actually, I put them in the title so that it was easier to determine. I mean, obviously you all are free to check it, but if you look in the email, our intention on 21 is to, basically just return the same proposal that you returned to us. We
Yeah,
don't,
I think we're.
we don't have, I mean, I have copies of it here to make it an official proposal back to you, but we don't have any proposed changes to the last version that we contemplated, so,
So I think, okay, I think we're.
so, just so that you have it officially,
Yeah.
here is.
Yeah, the last change was just putting and for the mail and the
Yep.
thing, so I think that's it.
So I think,
Okay.
21 is probably ready to be done with.
Mhm.
So I think we did some good work on that one. We made some pretty, you know, pretty significant changes, and I think we made some good improvements on that one.
Definitely.
So we'll move on to 22. 22 is similar in that, again, I'm gonna officially put it back across the table to y'all, and I emailed it to you, but I think we are also good on 22. The last thing that we were talking about was the day limit. I think the retroactivity of a limit for an award,
Mhm.
I think was the last thing we were discussing, and I think we are ready to go ahead and be done with that one as well. So I've emailed it to you. And again, our intention on 22 was to give you back what we received last time and kind
So
of.
60 days is what we agreed on?
Mhm.
Yeah. Okay.
So again, that shouldn't represent a change. All right, so let's move on to 23. Okay. Okay, I know this, this is one of the more technical ones. So I think there's not a lot of changes here, but we probably need to be very specific and go through it slowly, just because I know that we have had multiple back and forth conversations on these. So let's go ahead and, 23.1, that is just acknowledging that it's not just you all, it's both of us. And I'm not sure that's the first time you've seen that change, but I don't think that's necessarily a significantly substantive one. I know that we have gone back and forth about 23.2, and I wanna actually pull this up because I wanna make sure that if I describe something as CCL, I wanna make sure that I am doing it appropriately. So, in 23.2, I know we had some discussion back and forth, and I don't wanna put words in your mouth, but you basically, I feel like the GAU team felt like this was sort of confusing and or vague and not necessarily in our mutual interest to contemplate that first phrase of whether or not it was referred to. And I think, again, to sort of reiterate why that phrase is important to us is because we don't want there to be any argument about whether or not there was a subject that we should have considered within the agreement, and that is somehow, some way, shape, or form compulsory for us to open it during a period where we're not obligated to bargain. So, we're gonna reassert the need to have that, phrase. And then I know that you all had taken out the next phrase.
So wait, sorry,
Yeah.
in this version, whether or not referred to is still there. You did want to keep that in there?
Yeah, it's crossed out and now it's in there.
Yeah, whether or not referred to.
I thought you were saying you were striking.
No, I'm acknowledging that you all had sought to strike it and we
Mhm.
are interested in reasserting it.
Okay.
I just didn't want to just put it, I didn't want to just remove the strike and make it look like I'm not acknowledging that you all had
Yeah, oh,
tried to
okay,
take it
I
out.
see.
Like, I want to just be transparent to the fact that we're acknowledging that your previous version was suggesting a strike, and I want you to see that we are, even though it's CCL, I'm showing it in red because again, we're reasserting it even though it's CCL.
Okay.
Covered by this agreement. And then the next phrase, which same treatment I gave here, even though such subject matter may or may not have been within the knowledge or contemplation of the parties at the time of negotiator signing this agreement. We want to reassert that, bless you. But what we did was based on, and actually it's in your third comment, I think, and I think that's you, Sikander, with respect to what we thought we could do is specifically refer to Articles 24 and 28 to try to bridge that vagueness with the purpose. So we're interested in the language, but we feel a specific reference to 24 and 28 so that we want it to be consistent with those articles could be a way to possibly consider the language. We hope you would consider it that way. The other thing is too, is that when we get to 24 and 28, keep in mind that 28 is a new article that you're gonna be seeing our version of here in a minute. That's about the regulations. We feel that this is one of those sort of contextual ones with the way that we're suggesting the changes that we've sort of talked about with respect to 24 and 28, wherein it sort of outlines and draws perimeters around when, if we make a change unilaterally, or we feel legally obligated to make a change unilaterally, we have obligations to you, and we've outlined the ways in which we have to meet those obligations for whether it's impact bargaining or delaying implementation or so on and so forth. So again, the purpose of 23 is to insulate against having to reopen the contract, notwithstanding these reasons that we sometimes have to reopen the contract, if that makes sense.
Okay, so it's just protecting, just not, just reopening it for whatever, pretty much.
It should be-
It needs to be specifically stated, that it could be, reopened for this reason.
Again, for these narrowly construed reasons, because other than that, look, the ratification process is a very robust process.
Right.
The bargaining process is an extremely robust process. There should be a very narrowly construed reason for which during an agreed upon term, we would then say, hey, I know that we did all that work together, and I know that we agreed, and I know you all voted and we voted and we agreed to it, but now we're gonna go ahead and redo it again anyway, in sort of a pedestrian way of sort of explaining it. So, hopefully, again, if you would please just read 23 in the context of what we're also gonna sort of present to you about 24 and 28 and sort of look at it as one whole.
We've always looked at it that way.
Yeah, I mean, they're separate articles, but they do all kind of hang together.
Mhm.
Especially because we have made some changes, and I think frankly, some of the changes we've made back and forth have been good. So if we could then turn to 24.
So, I mean,
Yeah.
just to summarize again, so you feel that, these two lines at the end that you've crossed out are adequately summarized by this, this phrase here, that otherwise, except as otherwise provided in 24.
Correct. I mean, I think that you are not gonna get any disagreement from us that we believe when we make a unilateral change to the contract, our intent is when we make a unilateral change to the contract, if it's because of a required compliance legal reason, we acknowledge that we have responsibilities to GAU to discuss those. We may have to do them and we may have to implement them, but that does not absolve us of our responsibility to come and discuss those with you in an impact sense. Like,
Right.
and again, that's sort of a high general sort of
Mhm.
concept. There is no intention for us to get an end around to be able to make a change without having to, if it's a substantive matter of bargaining, for us to be able to just do that without contemplating our collective bargaining responsibility.
Sure.
So, all right, so let's move on to 24. We may be done early, Sikander.
Great.
I think but we do, I mean, I think we have 7, so
Yeah,
it's not
no,
like,
that's
it's not like we're
solid, yeah.
not doing, have a bunch, so, there's 24. Okay, so, The purple, it's purple here. We think that, and I believe again, correct me if I'm wrong, but I think Sikander, those are your comments on the right. I think that we're good on that previous language. We haven't changed it since you kind of identified that you're okay with it. So here's the big part on effective passage of the law. Again, I'm gonna look at it side by side just to make sure I'm doing it correctly. If any provision of this agreement is rendered invalid by subsequently enacted legislation that is later enjoined, repealed, struck down, or amended in such a way that permits the provision's enforcement, the language in the provision takes immediate effect. So in that situation, it's in the legal negative, meaning there was a provision of the contract that we stopped following because it became illegal. So that's situation one. However, after that moment, the action that made the provision illegal was subsequently enjoined or overturned. It basically, we revert back to the provision that's still in the contract that we had been suppressing, if that makes sense.
Right.
Back to CCL.
Basically,
Yeah.
okay, so that's part one. The next part is, if any provision of this agreement is rendered invalid by subsequently enacted legislation that is later wholly or partially upheld through a final adjudication, the university agrees to engage in collective bargaining with UFFGU regarding the provision and with the intent of preserving the language to the extent is permitted by the final adjudication. So this is in the moment that something becomes, we can't do it anymore. So it's kind of, timing wise, it's kind of backwards, but that's the way it's constructed and we're okay. So now the second part of it is, okay, we have a provision. And now something is passed, or there's a court case or something that says a regulation gets passed at the BOG that says, you can't do this anymore. And we say, well, it's in the contract, so we're gonna stop doing it because we're legally required to, but we have to get with you all and say, okay, look, this was in the contract. We're not allowed to do it anymore. Here's the reason why. What is the impact that we can sort of agree to over the fact that we are no longer permitted to do that thing? So I know that was kind of maybe more of a colloquial explanation, but that's my best attempt to try to make it.
Well, you said.
This is our language.
It is,
Yeah.
it is, again, but because we have the changes we made in 23, and I know you were concerned about, look, are we honoring again, we want to make sure that we're not creating unintentionally a sort of a place that you could get between the articles. Like, we
Yeah.
want to make sure that it's comprehensively locked down so that it's either here, or it's here, or it's here, and there's no conceptual way that you could sort of get between the different responsibilities, because that's not our intention. We want to make sure that they all work completely together as intended. Yeah, there's not a lot of change. I'm just kind of going through, again, our interpretation, so
Sure,
you could see
yeah.
our whole concept.
So then in that explanation, let's say if it's in the middle of the process, because when a court case happens and a law is being challenged, that, as we know, that takes a very long time.
It can.
So would you say that, because from what your explanation, would we impact bargain after everything's been resolved and then we impact?
So
Or
I
we
think,
want to impact 2 times, which would be one during, like, because you still have to follow the law unless there's an actual adjudication or something. So we would impact that. And then if the court case is settled, something happens and that changes again. then
Wait,
we
can I
would-
just say something? Because when I had made this proposal, that was what it was supposed to be, kind of sticking to how we
Right.
did 17,
Yeah,
which is,
right.
that's why we left in their insertion at the end of 24.1.
Right.
Which is that we would still impact bargaining even
Right.
after the law has been passed.
Yeah.
But this stuff in 24.2 allows it so that we can also
Right.
impact bargain it so that the language goes back into effect if the law so.
I
requires.
totally agree.
correct. Yeah, a lot of it has to do, quite frankly, with the timing of it. So sometimes, well, at least we had a couple of laws that were passed, not the current session, but in the previous session, where, like, in that session, the enactment of the law was required July 1. Well, that's not a whole lot of time, practically speaking, because
To impact
sometimes,
bargain,
I
right.
mean, you have to impact bargain, and they were pretty big issues. And quite frankly, there's not a whole lot of time between when legislative session stops and July 1 is like right around the
Right.
corner, so. And summer sometimes is difficult for us to get together and do something meaningful, because some of you are, some of us aren't available, some of you aren't available necessarily, so it's tough. But that doesn't mean that just because we have to take an action, that we don't have an obligation to meet with you all and say, hey, look, this law passed, we have to do this thing, but what are we gonna do about it together?
Okay.
And I think your example of 17, which is one of the reasons that I think a lot of that language is it's not exact, but it's pretty close.
It's very similar.
Yeah, it's very
Yeah.
similar, and we think it's decent language, we think it works.
Yeah, because I mean, it seems like it's gonna be happening quite a few times in the next few years already. That laws are passed.
And I think it remains to be seen, but I do think that it's, the provision is, I think the provision is robust enough that we sort of all know the rules of the road in
Right.
terms of,
Yeah,
this is how we're gonna proceed if and when that were to
and
happen.
we have the experience from Article 17,
Right.
we know what we need to do.
Well, and knowing that 3 years from now, hopefully you have all successfully completed your program.
Yeah.
and graduated, there's gonna be a different group of GAs that are gonna be like, wait a second, so what happens exactly?
Yeah.
Like, this provision being in
Right.
here is helpful and instructive.
Right, right.
And then in 24.3, authority except as set forth above, the article is not intended to cede authority to any party to invalidate any provision of this agreement, which I believe was your language, our suggestion. And we really are, we rewrote it slightly because you had UFFGAU does not concede to the constitutionality of any subsequently enacted legislation that invalidates the term of this agreement. The UFFGAU may choose, but neither is obligated to challenge said legislation. I mean, we don't need to contractually agree that you have a right to bring a lawsuit against whoever you all are gonna bring a lawsuit against. Go right ahead. We're not gonna, that doesn't need to be included in our contract, that you have a right to go sue
Okay,
somebody
yeah,
else.
sure.
If you all want to acknowledge that you're not gonna cede any authority to a party to invalidate a provision of the agreement, we believe that that statement needs to be constrained by an acknowledgement that authorities do exist that can legally restrain that, or like the legislature and the courts do have the ability to. We don't want to get in a constitutional argument with y'all, be like, well, the contract says that we're not gonna cede that authority. We're like, but it's the state of Florida, which we have to be able to acknowledge has a right to tell us to do this now. Everything in 24.2 is, there's all these mechanisms that exist, whether it's a subsequent law, whether the courts agree, whether it goes to the Supreme Court even, that can enjoin, it can overturn, it can whatever. But in the meantime, the university is gonna continue to recognize the constructs of the state government of Florida and some federal agencies that we have to do what they tell us. So, all right. So that's 24, and then the last one is 28.
Wait, hold on. Do we have any other questions?
Go, sorry, go
about-
ahead.
No.
Yeah, go ahead.
So then we'll go to 28, and I'm gonna be transparent. I think 28 is probably the one that we probably have the least flexible, like, we're gonna probably demonstrate the least amount of flexibility based on how we've been going back and forth on. So I'm just gonna say that up front. So 28 is the new article that you all had proposed about Florida regulations and policies. So basically, if the university is required by law or Florida Board of Governors regulation to adopt a new regulation or amend an existing regulation that has a direct and substantial impact on wages, hours, or any other term or condition of employment, the university and UFF shall or will bargain the impact of the change in accordance with Article 24. So that's the reference back to 24. Implementation may proceed prior to the completion of impact bargaining in such cases. I think that most of that is exact language that you all have seen before. So in B. What's that?
Looks like Cantor's comment is like completely like.
Oh, yeah,
Yeah,
it's like,
it's
ghost-
like, yeah.
I don't know. I wasn't like a setting that I intentionally did. I'm sorry, I don't know why. I can't even read it.
Yeah.
Okay.
Okay, so here's where, and Brandon, your question about timing may
Yeah.
come into 28.1B. So here is where we're not really sure, and you can see my comment, which is in red, which is, so the difference between proposing and adopting is important, and here's why. If we're gonna propose if something is gonna be proposed, we've already stipulated that we're gonna satisfy our obligation prior to implementation. But we don't want to necessarily have to impact bargain when a regulation is proposed, because the BOT is not going to be constrained in adopting a regulation based on bargaining. So in other words, if they adopt a regulation that has an appreciable impact, we've got a collective bargaining responsibility that we have to resolve. But they are not going to wait until we bargain something if they have to take an action. Because you're already protected from implementation. And I think that's probably the best way I can explain it. Olivia, does that capture it appropriately, or do I need to add more detail?
That makes sense.
Okay.
Can you explain how exactly, okay, what part of the language makes that clear in the sense that we are protected from the implementation, even if the university can
It says, so in line 14,
15, okay.
yeah, the university shall satisfy any collective bargaining obligation with respect to the change prior to implementing it, unless UFFGAU declines in writing to bargain. So, if they were to pass a regulation that, impacts, substantively, directly and substantively impacts wages, hours, or a term or condition of employment, we would not implement that change on your, on the bargaining unit members until such time as we got together with you and said, okay, look, here's this new regulation, we've got to do it. Obviously, except as constrained in 24, where we have some sort of legal compulsion by a deadline to do it, where we're not constrained to delay implementation for a legal reason. So that's again, where it's a little confusing, because there are situations in which we have to go ahead and implement it, but not based solely on the regulation. If it's based solely on a regulation that's discretionary and not compulsory because of an outside, because of a legal reason, we wouldn't have the ability to wait. But if it's a regulation that we're passing, that we're not legally compelled to do it by a certain deadline, and we're able to delay implementation, then we would.
Okay, so in the case of, there's a law requiring to change the regulation, you'll have to implement it regardless of what the contract says. But if you adopt, not propose, but adopt a new regulation, so that's been changed.
Right.
But there wasn't a reason, compulsory reason by law to do so, then it doesn't affect us until we bargain and then change it, because the contract.
We have to delay implementation.
Correct, okay, then, okay, that makes sense.
That's the, again, sort of the ways that the three articles are,
Right.
we intend them to sort
Okay.
of work together.
Okay. I think that makes sense.
I mean, I'm still concerned in the sense that, 28.1B still basically allows the university to adopt new, and I mean, okay, maybe I should let you finish, go through 28.3 especially.
Yeah, so unless obligated by law, so yeah, so you had suggested, unless obligated by law or Florida Board of Governors regulation, no existing new or amended university regulation, policy, or resolution shall apply to bargaining unit members if it conflicts with an express term of this agreement. Again, we feel that it's duplicative of what we've agreed to in 28.1B.
I think it's-
Because here, essentially, the university adopts a new regulation, and it can conflict with an express term of the agreement, and then you would just be obligated to bargain the impact of that subsequently.
Well, not only are we obligated to bargain the impact, we can't implement it until that's done. 'Cause
Right.
that's a big difference, because if we are delayed from implementation until we satisfy the collective bargaining part of it,
Right.
that's much different than we changed it, so now we have to do it right away. Because if we were to change it, we still have to impact bargain with you all before we can implement it, which is very different than a July 1 deadline. Okay,
Right.
you have to change the regulation and we have to implement it. We have to impact bargain, like you had said, in that case, we're already off to the races because we've gone ahead and done it. As in this case, we could change the regulation. We're not going to be told that we can't change the regulation, but we won't be able to implement it until we've satisfied the collective bargain.
So I think the only thing with that is that there's a difference, so that now there's a difference between adopt and implementation, right?
Correct.
And so there's no language in here that says that if it's not required by law, implementation is delayed until we impact bargaining the adoption of the new regulation.
The opposite is contemplated in the previous article.
Right, so that's pushed by, which I understand. If
Yeah.
it's by law, you have to do it, we have to impact it, yes. But if it's not required by law and it's adopted, there's really no, kind of like what Sikander worry was, there's really no wordage in here that says the implementation is delayed until we impact. It just said that we have to impact bargain, for whatever the regulation is conflicting with our contract. It doesn't say that implementation.
So it
Unless I'm
actually,
misreading.
it doesn't put it in an impact situation. It actually says the university shall satisfy any collective bargaining obligation with respect to the change prior to implementing it. That's different than saying we're
okay.
gonna bargain the impact.
So then that's saying that
So
the
I mean,
university shall satisfy, so you're saying that the regulation will not.
I mean, effectively, we will have some say in what the regulation is. I mean, that's.
So I wanna be careful about I don't wanna misspeak. You won't necessarily get to have say in what the regulation is, but it could be an exceptionally long time before we can implement it as written if we haven't satisfied our collective bargaining obligation.
Mhm.
It's not the same as impact bargaining.
Yeah, I guess, I'm thinking through like hypotheticals here, right? So this is a very extreme
Right.
example.
Yeah,
The-
go ahead.
The Board of Trustees says, we're not gonna pay graduate students more than $15,000.
Okay.
Limited, that's against our contract, we'd have to discuss it.
Right.
We want to protect our existing protections,
Mm-hmm.
what's the process that you would go through there? Because it's different from impact bargaining. We're not
Yeah,
just changing the contract to say it's maxed out at 15,000 now.
It's a fundamental, it's a substantive issue of bargaining. You've done it unilaterally. You passed this regulation. Now you're trying to implement it to your. in
Right,
that
so you're
example.
saying we would satisfy collective bargaining with respect to the change prior to implementing it.
Right.
But we would not be happy with implementation of that at
No
all,
matter
right? So,
what. So, I mean, I'll defer to Olivia, but I believe the process would go, we would bargain it, and then if we don't come to an agreement, we would go to impasse at bargaining.
Mhm.
And I don't believe, now, once we get to impasse. In that situation, because it's not really impact bargaining, I think we would wind up at impasse is what would happen.
mhm. What would happen in past? I'm not familiar
And
with.
there's like an arbitrator.
Well,
it's
so
like a
you kind of in
third-party
front of a special master, there's a third party that comes in, we present our case, we talk about what our last best final is. We have to, there's a presentation on either side, that person renders a recommendation, that recommendation go to the board. I may be making it faster than it happens, because it takes, it's a process.
Think, yeah, we
Yeah.
really don't wanna go there.
It's not.
No.
It's personal opinion, not speaking on behalf of you. My personal opinion is it's much better to reach an agreement for all kinds of reasons than to wind up at impasse.
Yeah, but I guess in an extreme example like that, there
has to be
no
done
way we would
sometimes.
agree to 15,000. In a chance that, because you can unilaterally pass whatever regulations we want, we don't have a say in those regulations.
Right.
So if those regulations are a very serious conflict, like in that example.
Right,
And there's just no way we're ever gonna agree to anywhere close to that.
Yeah.
Then, that's kind of, this is saying that's where it's gonna have to head, to the impasse.
yeah, I mean, I think you actually have, and I'm not gonna go through all of them, but I think you actually have a number of different tools at your disposal if we were to
Right.
take some sort of unbelievably
Mhm.
extreme adverse person, like
Right.
some unilateral, contract violation action like that. I mean, I think the university would probably be subject to a number of different mechanisms you have at your disposal. It wouldn't just be this.
Right, okay.
Okay, and I'm just not familiar with some of those
Yeah.
things, but.
Yeah,
So we'll probably just have to talk about that more.
Because that is really the main worry, is that since we don't have a say in what these regulations are, we just have to. It's not impact bargaining, but we're necessarily kind of impact bargaining in the sense of that.
Yeah.
It can't be implemented till we reach an agreement, but something most likely has to change because we are bargaining. And
Yeah.
then if we don't agree to that at all, like if the new regulations is something we just don't even want to consider, then.
I can understand why I would feel bad that, again, in Austin's example, where if the BOT were to pass a regulation that did something that extreme, even though we wouldn't be implementing it, it's gonna feel really bad for GAU for that regulation to be on the book somewhere, even if we weren't currently implementing it.
Right.
I can understand why it would put you in a very tenuous position. I appreciate that.
It's also just weird because they're technically our employer, so this, like, the conflict is just, yeah.
Yeah,
Yeah, I mean,
The whole
there's,
thing.
yeah, the university shall so the language, it's not impact bargaining, like you said, the university shall satisfy any collective bargaining obligation. That's really just referencing just the, coming back to the table to discuss the changes, that's not really.
Right.
That's all it is.
Yeah, it's more of a reference to the totality of the agreement.
Okay,
Because
Right.
in the cases that are, which is Article 23, whereas in the cases where we're legally obligated to make the change, that's really gonna be dictated by.
Well, yeah, I think we understand the
Yeah.
legal obligation, it's just more so worried this, if it's not an obligation, but it's gonna seriously affect us, then, you know, we have to pretty much bargain to keep whatever protections we had that we wanna, you know, we wanna keep the status quo.
Right.
And that'd be-
So I think and again, I don't want to make your arguments for you, but if
Yeah.
I were to look at 28, and Olivia, again, feel free to step in and correct me. If we were to look at Article 28, I'm not sure, depending on the facts of the specific case, if we were to have a regulation that substantially changed a term and condition of employment. If it reverts to Article 23, I'm not sure we could compel you to the table before the term of that contract expired.
So you're saying you'll have to satisfy the bargaining agreement until whatever, through full book until
Right.
we can actually. talk.
The way we've constructed that, Olivia, if Article 28 was brought to bear in a non-impact situation, could we, the way we've written it and proposed it, could we compel them to the table prior to the next full book session?
Sorry, I have to admit, I'm not following your question. I'm sorry.
Okay, so under 28.1, that we have to satisfy our obligation prior to implementation. In a non-compulsory, like statutory situation where Article 24 is not contemplated, would Article 23, specifically 23.2 override? Based on our proposal, is it our intention that GAU would be empowered to delay considering the matter until the next full book?
Sorry, 23.2 says what? I'm sorry, I
23.2
don't have everything open in front of me, so
Oh,
I'm
I'm
not able to
sorry.
cross-reference 28 with
Yeah, I
23.
apologize. So 23 is the totality, which says nobody's got to come to the table until the end of the term.
Well, I mean, I just think we need to remember that 23 is the totality of the agreement. It's really just meant to say, this agreement covers everything that the parties talked about, and everybody had the opportunity to bring up what they wanted to talk about. Everybody bargained what they needed to talk about. We don't have to bargain anything else except, and everything. It is what the heading is. It is about the totality of the agreement. It's pretty standard language that's not almost every single contract.
Right. No, I
So-
get that.
We need to kind of separate that from our thoughts about, you know,
And my question is in a
Impact
simple
bargaining.
sense, because I'm gonna ask Brandon's question differently, because I think this is what he's getting at, and to some extent it's a candor. Here's the question. The question is, if BOT were to change a regulation that it wasn't obligated to change based on legal compliance,
Mhm.
would that be considered, would we have to satisfy an impact collective bargaining obligation? Or would it be a substantive bargaining situation, in which case would they be shielded from coming to the table under the totality of agreement article until the next full book?
I mean, I think it depends on what the regulation is regarding.
Okay. So it's fact dependent on the situation.
Yeah.
And
I
then
mean-
what would that mean? I mean, only if it has a direct and substantial impact on wages, hours, and other terms and conditions of employment, would that be the situation?
Well, yeah, I mean, like, 'cause if we change a regulation that doesn't even
But-
affect you, I mean.
Yeah, but I'm just rereading these three articles here.
Yeah,
Since Article 24 is really just talking about being effective of any law, and whole thing, that doesn't really matter, and that's really where the impact kind of comes from that.
right.
So it would be my understanding that we wouldn't have to bargain until full book, because it's not, because there's no impact there. It just says we shall satisfy any collective bargaining obligation.
That's how I understood your question, which is
Yeah.
why I was trying to ask.
Yeah,
it.
that makes
I was trying to
sense.
ask it in a different way,
Right.
because that's what I was taking from your
Right.
question, and frankly, I was not sure. That's
Yeah,
why I
so
was asking
what's
Olivia.
that, so Olivia, then, what would force us to the table? Like, well, I'm just really confused, because you said depend on the facts of what the regulation is, doesn't seem like, doesn't matter what the regulation was, it doesn't matter what it was. We can still wait until full book according to, like, at least from what I'm reading here. So if there is a case where we would be forced to the table, I just not seeing it.
Immediately,
Yeah, So,
Yeah, let's get back to you on that, but I think it's a good
Yeah.
question. I'm not, and I'm just being honest, I'm not exactly sure. So
Yeah.
let me,
yeah,
let us talk about it a little bit and we'll have an answer for you.
okay.
I'm just not.
Yeah, I think making.
I
it
think
clear-
it's a decent
Yeah,
question.
It's very important because,
Yeah.
you know, if we are forced to the table, then that's pretty much impact bargaining.
Mhm.
And I don't think that's something we really want, is to be forced to the table whenever you pass a regulation.
I get it.
you know?
I
Yeah.
understand. I understand.
Okay, but I think at least on the law side, like
Yeah.
I think, at least I,
Yeah.
I understand the
I-
intention, I think we're.
Yeah, I think overall, when we went through these, especially because we were able to sort of return two of them back to you without any changes, I feel
Yeah.
like on some of these, and I realize there's some of the smaller articles, but getting them sort of cleared off the deck and getting them done, I think is gonna feel good. So the last one that I wanted to bring up actually was 13. Because I think, I'm not 100% sure, but I think Sikander, when you sent them last time,
Mhm.
I think you inadvertently resent us ours and not yours. So if you go back and check, because when we looked at your Article 13 proposal, it looked identical to the one we had given you previously.
Well, we didn't have a proposal. We didn't get, you guys gave us the proposal, so I had just sent that so that Austin could throw it up.
Well,
I-
no, I got an email that says, here are proposals from the day. And so I think you may have like inadvertently included that one.
No, I had included that because my laptop ran out of battery and I still needed Austin to.
Because we were discussing it from you
Yeah.
sending it the previous.
Gotcha.
Yeah,
Okay.
Yeah,
Okay, good.
I think it's still on our.
Yeah,
Okay,
it's
so
on
you
our
guys still
side
have
of
that.
the
Yeah.
Okay, so
Yeah.
if we have some time, would you guys mind kind of going through, like, I have the scorecard up. I just want to make sure we agree on who's got which one.
Yeah,
Right.
sure.
So by my count after today, I think you guys have, and that's why I want to talk about, because I want to make sure we understand who's got which one. And we're working, by the way, I think we're really close on 8.
Yeah, I think
Yes.
that's
Mhm.
right.
Yeah,
Like
we were-
we came up with a new, basically, we came up with a new, just it happened to happen, like we were ready to bring it. We had a new situation come up where we believe it's of mutual interest to maybe include another provision.
Mhm.
So we just want to have another week to sort of look at that one. But we think that you guys currently have, we've signed off on 1, 2, 11, 14, 15, 17, and 18. We have, you guys now have 4, 5, 6, 7. After today, you also have 9. You still have 13, 19.
Well, 19 is one of those ones where it's like, I mean, I don't think we're gonna have like a big
It
debate.
may have been a CCL.
No,
proposal,
it's
but-
not. Well, I mean, I think we should just leave it till the end because it's one of those where it's like, okay, if we get to one of these articles where, all right, we do want to come to an
Gotcha.
agreement, but it's not gonna be
We're gonna
possible
wait.
this time. Let's make
Oh,
an
okay,
advisory
right,
committee
right,
kind of thing, yeah.
20, 21, 22, 23, 24, 25. And then now you have 28, and then the one that
And
I
then
had
25
called,
is
like,
also,
2X.
yeah, and also 25 is similar to
Same
19,
thing,
yeah,
yeah.
yeah.
And then we've got 3, 10, 12, 16, and 8.
Okay. Yes, that's right.
Does that sound right?
Right.
Okay. All right, I think the one for, in terms of what we're probably gonna have for next week. I just got a bunch of the information on 12, but I don't know if I'm gonna be ready to present the proposal. I may have some information to present. But I don't think I'm gonna have a proposal. I do hope that we will have 8 next week and we might have 16. We're not gonna be ready on the other ones. We're not gonna be ready on 10 for a while, so.
Do you have like any type of estimation for like 10 and 12, really?
12 is gonna, well, 10 and 12 are pretty inextricably linked.
Yeah.
And I honestly, I don't, it's gonna be a bit.
Okay.
So, all right. Thanks, guys.
Yeah, thank you.
Thank you.
I think we're making really good progress.
I think there's like, yeah, a lot of these ones today are pretty much,
Yeah.
yeah. Okay, guys,
We'll get out of your hair so you guys
let's
can go.
do
your
debrief then, yeah.
Yeah.
I could be in trouble.
I'll send the link. to the chat.
Well, they don't need, they,
What?
There we go.
they've,
I'll just open the new one then.
Oh,
Yeah, man, there's two, where my pen?